What happens when family law and criminal law intersect? Find out next on Practical Law. Stay tuned. Welcome to Practical Law. I'm your host, divorce and family law attorney Henry Gorenbein. I'm also pleased to say that Practical Law is now being co-sponsored by the Oakland County Bar Association. I specialize in family law, and there's an old saying that in family law, we represent good people on their worst behavior, while in criminal law, a criminal defense attorney represents bad people on their best behavior. Today on Practical Law, I'm pleased to welcome family law and also defense attorney George Safaropoulos as we discuss the intersection between family law and criminal law. George, welcome to Practical Law.
Henry, thank you. It's my pleasure being here.
George, first of all, why don't you tell our viewers a little bit about who you are and what your background is?
Thank you, Henry. Well, I've been practicing for a little over 13 years now. Various career paths prior to that took me from New York to St. Louis, and I was fortunate enough to meet my wife, Teddy, who kind of helped me get that light switch on in my head, and I decided to go to law school. And it was the best decision I made, and I don't look back on it. And today we have two beautiful kids. And again, my wife's been so supportive, and as you know, having a supportive spouse really makes this job a lot easier.
Right, and you and I have had cases, and I've always found you a gentleman and a pleasure to work with, and sadly, there aren't a lot of attorneys out there like that.
Well, Henry, I appreciate that, and I feel the same about you, and that's why I was eager to do this show with you.
Thank you.
You're welcome.
Why don't you tell our viewers about the, kind of your practice and the focus of that?
Well, the focus of my practice is family law and criminal law. And if I had to break it down, I probably do more family law than I do criminal law. But this topic, which I was invited to present at the ICL seminar back in November, really got my juices flowing a little bit here because we see it so often in the family law side, as far as the intersection between criminal law and family law. And so that's what I do. That's what I predominantly have been doing for the last 10 years out of the 13 years that I've been practicing.
Let's start with, tell us what you mean by the intersection between family law and criminal law.
Well, many times, and we see it in family law cases, we have a client come to us, whether they're interested in filing a divorce action or they've been served with a divorce action. And many times the reason for that would be an underlying criminal case. Either we're representing a spouse who's been arrested and charged with domestic violence, or there's another underlying criminal action that really is the root of why they came to us seeking family law guidance.
Let's talk about domestic violence and give us some examples where that could play upon, a divorce scenario.
Sure. In domestic violence cases, many times, we have an individual come to our office who has been arrested, has been arraigned on a domestic violence charge, and at that arraignment, there's a no contact order with their spouse, and they can't go back to the residence. Now, whether they have children or not, there's a lot of issues that come into play, being how do bills get paid? If they do have children, how do I see my children? How do I retrieve my belongings from the house? And they can't contact the spouse, so they need an intermediary to do that. Or they've been filed with a family law action, a divorce, because of the domestic violence action, and then they need someone to work with to resolve the family law issue or the criminal law issue, depending on why they came to my office. And many times, if they came to me for the criminal law action, I'll refer the family law action out. If they came to me for the family law action, I'll refer the criminal law action out.
Why wouldn't you do both? Is there
too
a conflict?
It's too complicated. You're dealing with someone that we know from the family law side, it's emotional enough when someone has to confront their marriage dissolving.
Right.
When they're presented also with a criminal action and the threat of jail and the bond conditions of do not go to the residence, no contact with their spouse, they can't see their kids, it's too much for, I believe, for one attorney to handle. And I think it's better for that attorney to be focused on one action and refer the other action out.
What about, do you ever have cases, and I've had cases, where either someone is set up or making false allegations? Do you see that very frequently?
You know, I don't see where they've been set up or they're making false accusations. I think many times we have individuals come to our office and before any discovery by way of police reports come to light, they may initially make that, and that's the small percentage of cases that come to our office. But once the police reports come and you can question the individual a little bit more and more evidence is presented, that really doesn't happen. Now, occasionally that does, and that's a good point. It does, and when they're confronted with that, that's a case that invariably, at least in Washtenaw County, gets taken to trial. There will be no dismissal of the charges, even if the victim says, I made it up, there is no domestic violence here, that didn't happen. Prosecutor's office has a standing policy where they will not dismiss, and they'll take that case to trial.
Now, this brings another question. I mean, I've had cases where there has been domestic violence, but then people are trying to reconcile. And so they don't want to go to trial. Is this where normally there's a plea worked out, or what happens?
Many times there is a plea worked out if they do want to reconcile. It's a touchy area for the criminal defense attorney, because if your client comes to you and says, I don't believe my wife or my girlfriend or my husband or my boyfriend is going to show up to trial, obviously you can't counsel that individual to instruct that other party not to show up. Obviously there's serious ramifications for the attorney to do so. But if they do retain an attorney, and many times the victim, the alleged victim, will retain an attorney in a domestic violence case where there's no intention to pursue it, you can have dialogue with that attorney, and many times that attorney will communicate with the prosecutor's office and try to work out some sort of resolution. Or if it does go to trial, they'll counsel that individual on their testimony at trial. And when we're speaking of the victim here.
George, what about substance abuse issues?
Unlike domestic violence issues, many times with substance abuse issues as they relate and intersect with family law matters, a lot of times there's not a pending criminal action. It's just the use, the abuse of alcohol, prescription drugs, controlled substances has that impact on the marriage that's just broken the marriage down. So you don't have that threat of jail or a pending criminal law action that's hanging over a family law action. However, occasionally you will have an arrest that, just like in a domestic violence case, is the impetus for a family law action to proceed.
I've had cases, and again, where there'll be a DUI or a drug arrest where it coincides with the divorce and becomes an issue with regard to, I mean, by way of example, I had a case where I was representing the wife in a divorce, and she was caught drinking with an open container with the children, and it cost her custody. So,
absolutely, and I think we've had similar cases. I've had cases where there's been either drunk driving cases, where there's been a family law action as well, where the individual's abusing alcohol or prescription drugs. And what I like to do in those cases is counsel my client, number one, if they accept that there is an issue and there is a problem, that they go into counseling, that they test regularly, because that can be used to the client's benefit in the family law action, especially if there's kids involved, where you can demonstrate and show the court and show the other side they're in active counseling, they're being tested regularly, and I find by doing that and counseling the client to take that initial step to do so, it helps with visitation and parenting time issues when there is a pending family law action. Because I think you've seen it as what we have, where if somebody has a drinking problem or a drug problem, there's that initial threat, you're not going to see the kids.
right.
And I think if you can counsel the client to be tested, to go to counseling, and as long as they're testing clean and they're in counseling, it takes away, at least in the court's mind, I found, the possibility that the children could be in harm's way if this person is doing the things they need to do.
George, what about marijuana? I mean, that's becoming a bigger and bigger issue. We now have a lot of people walking around with marijuana licenses, medical marijuana licenses, and I know I've had a couple judges on the show where we talked about the impact. And what are you seeing in your practice with regard to that issue?
Well, I've seen the clients, I think, don't understand the statute really as it pertains to custody actions with children in a family law case, where, well, I have my medical marijuana card. I can smoke whenever I want. I can use whenever I want. Well, that's not, and it can't be used against me in a custody proceeding. That's not necessarily true. They can't be under the influence of medical marijuana when they have the children in their custody. And you need to explain that to the client. And you've seen it as I have, and you've talked to judges. No judge in their right mind is going to allow someone, just because they have their card, to use marijuana when they have children in their care and custody. So there's that delicate balance there of somebody that does have their card and the right to use, but how do you parent your children effectively and according to the statute, even though you do have that card?
Plus, you're still dealing with the fact that federally, it's, even with a medical marijuana license, it's still an illegal substance.
It is, but if you've seen so far with this administration, the Department of Justice has taken a hands-off approach as far as going after people pursuant to federal law.
George, let's go to another area, and that is personal protection orders.
Sure.
And I deal with them some. They're common in some cases and others, and sometimes they're wrongfully issued. Tell us about that issue.
Well, we have domestic relation PPOs, personal protection orders, non-domestic personal protection orders. I find, and I see it in my practice, where if there is an underlying domestic violence case, that many times the victim is advised or instructed to go seek a personal protection order. And a lot of times that's good advice, particularly if the person who's charged with domestic violence or the person that needs to be restrained has a license to carry a firearm. And we'll see that many times that's why the individual will go to seek a personal protection order, is to get that order so that person can't carry that firearm. And also, it's entered into the law enforcement network, information network. So there's an added layer of protection there. If someone does have a PPO out against somebody else and that person violates, that the law enforcement authorities right away know that there is this personal protection order and this person, what the restrained behavior is.
George, what about domestic relations PPOs?
Well, in those cases and how they pertain and how it affects particularly child custody proceedings, Henry, would be if there is an underlying domestic violence case and there is a PPO as well, and the individual is not allowed to have contact with the victim, nor have any contact with the children, or is restrained from even engaging in any parenting time discussions, we can use the domestic violence case and the no contact order that's been established as the bond condition and work to get the PPO modified so the parties can communicate either via text, email, to work out parenting time exchanges, schedules, issues involving the children.
And what about stalking PPOs?
Stalking PPOs we see a lot now, especially with social media and what's been going on with social media in the last 10 years, where people aren't only stalking by showing up people's workplace, following them in their vehicle, but it's also on the internet, and it's through Twitter, Facebook, and the like. And we see an email, and we see a lot of stalking and harassing behavior as it relates to social media, and the courts get involved by way of PPOs.
We had revenge porn sites, and I know I've lectured on that topic, but you know, that's an issue now, and now those who've operated those sites, they've been criminally prosecuted in some states. I don't know if that has bearing in domestic relations, but it is also an issue.
It is an issue, and I've seen in criminal law where the videotaping of someone engaged in a sex act, if that sex act is even consensual, but videotaping without their consent is a felony in this state.
What about, are there any other non-married abuse situations that you deal with where it could impact on a marriage?
I don't know if you can repeat that, or I'm not sure I understand.
Domestic sexual assault, I'm thinking of.
Okay. Or non-domestic sexual
Yeah,
assault.
yeah.
And I think it goes to, in a way, to the revenge porn site, but taking it a little bit further, it's people sending explicit messages or images to someone via social media, via email, via text messaging, where that individual feels threatened that this person is capable of committing a sexual assault on the individual that received the images or the communication. And we're seeing more of these non-domestic sexual assault PPOs because of this type of behavior.
Now you're looking at it from a criminal perspective. I guess my question, if we swing over to the family law side of the fence, where you're trying to negotiate a settlement or preparing for trial, did the judge really give much credence, or even if it's something that's provable, what does it mean as far as monetary damages? That's an area that I see where the courts really don't do much. And what is your take on that?
Well, I haven't seen much as far as monetary damages, as far as if there's been domestic violence or if there's been some other criminal action, how it relates to the family law side. Obviously, if there's fault and if this criminal behavior is the reason for the breakdown of the marital relationship, then obviously we've seen courts divvy up the pot, so to speak, more in the victim's favor if there has been. So I hope that answers your question. I don't know if there was another area, if you're going by way of tort law or anything like that. I know you specialize in tort law, and earlier we had an interesting conversation about that. I don't do much tort law, but you opened up my eyes to a lot of
Yeah, well, it's an interesting thing as to, it's like, we're not going to touch tort law really, other than to say that in family courts, it seems to me the judges, they become jaded. We're what is called a no-fault divorce state, but we're also an equitable distribution state, which means that fault can come into play. But in my practice, I've found that it has to really shock the conscience before a judge is going to go much off of 50-50 when it talks to property division.
And that's a great point. And what I see in my practice a lot, and this may have been 50 years ago where someone has cheated on their spouse and fault would play in a role in that. Jaded is great. I think the courts have seen so much of that. We know, well, the marriage is already broken down by that point, so we're not going to penalize the party that strayed from the marriage.
What's the chicken or the egg?
That's
I mean,
exactly right.
If I'm representing the person at fault, I'm saying the marriage has been bad for years and sorry, it happened. And the other side is saying, well, the marriage is fine, and if you hadn't strayed, it wouldn't break up. So the judges hear these, and they're, it might be, instead of 50-50, it might be a couple percentage points.
Yes.
And what I've learned, there has to be something really extreme to even get to 60-40, and I don't know of any cases really going beyond that.
The only thing that I could see, and I haven't seen it yet in my practice, but I've heard about it talking to other attorneys, is where child porn comes into play, or there's been some sort of sex abuse of a child that has come into play, where the courts, I think, then their social conscience, I think, gets affected a little bit more, and there could be. But it has to be something extreme like that before a family law judge will.
Well, I had like a 6 or 7 month marriage where there was child porn involved, and I had the wife, and the husband ended up going into jail, but there really wasn't much to fight about.
At that point, there isn't.
Yeah.
You're absolutely right.
What about issues with regard to, we talked about sexual assaults. You see clients, you're identifying, are there certain traits you're looking for when you're interviewing a client that might lead to some type of criminal behavior or something that you can see as an issue as you're getting into a case?
Sure. So if the initial red flag it doesn't come forth by way of a domestic violence case or another criminal law matter, the state puts out a great screening protocol. It's called the Domestic Violence Screening Protocol for Mediators. And I like to use it with my clients because at that point you don't know whether the person is a victim of domestic violence or if they are the person who is committing certain acts of domestic violence, which, as you and I know, don't have to be physical. It could be it could be emotional abuse, psychological abuse. It could be monetary, controlling finances. It could be controlling the male, isolating their spouse from their family and friends, using the children as a means to to exert control. And really it all comes down into control and how many different ways an individual can control someone else. So the state puts out a great screening protocol, I believe, that I like to use in my intake and run through questions.
What are some key questions that you ask, George?
Well,
with
I
regard
like
to this area?
I like to ask about how do finances, how do bills get paid? Who controls the finances? Is it equal access to joint accounts? This one really opens people's eyes, but mail. Who gets the mail? A lot of times I found in my practice, and I've read, where people that are control the mail. They don't give access to the mail to their other
Right.
spouse, and they control information. And if you control information, you can control a lot of what goes on in the relationship. So the screening protocol goes through a lot of these questions. It also looks at it from a mediator's point of view, but we do tend to mediate a lot of cases as practitioners, or engage in mediation, excuse me. Do you feel comfortable sitting in the same room as your spouse? Would you feel comfortable using the same entryway and exit to show up for mediation? And you'd be surprised how much an individual will engage with you then, if they're willing to, about certain things. And then you have different, based on the answers, then you can pursue in greater detail acts of domestic violence or threats of sexual or physical abuse or emotional abuse, or threats of self-harm as a means to control the other party. If I don't get my way, I'm going to cut myself, or I'm going to do something like that. So I think that screening protocol does a great job, and I think all attorneys should. There's a link to it through the SCAO website that you can get.
Yeah, I'm a certified mediator, and to keep up my certification, last month I took an 8-hour domestic violence screening protocol seminar, and so.
And I hope that you found that the screening protocol was very informative, because I like to get the word out about that. I think it's very informative for practitioners.
And what's interesting, I mean, I've had a lot of cases. I had one where they lived in an isolated area. The husband was very, very controlling. Custody was an issue, and I remember he comes in for a meeting either with a friend of the court or psychologist, and his pictures had him and the children, but there are no pictures of the wife.
Wow.
Or there was another one where the wife was instructed where to go for groceries, and if she came back and didn't buy a certain item that was on sale, she'd be sent back to return it. I mean, I've seen all kinds of really crazy controlling
It
situations.
is, and very extreme. And I just finished a case where, in the mail issue, the who controls the mail was a first for me. And we found out that the husband had the only key to the mailbox, where they would open up it was a community mailbox, would get the mail, would selectively give the spouse what mail that he deemed she should have or wanted her to have. And then it got beyond that. He would take her to work and pick her up from work all the time, pick her up for her lunch hours. He would coincide both parties' lunch hours, so he would pick her up and drop her off, really limiting her contact away from him with people. And that was one of the toughest cases we had. It was tough for me to get my client to feel strong enough and confident enough to engage in a divorce action where she should get what she really was entitled to, but get the strength to fight for herself. And I think what I like to do, and I'm sure you've done as well, we're attorneys and counselors at law, but we're not really psychologists. So I like to engage a therapist whenever I can with my clients, to kind of help them find that strength and assist in the divorce action.
Well, I work with therapists on a lot of my cases, and kind of my mantra is I send people into therapy for three reasons. First reason, to see if they can save the marriage, because a lot of marriages come to attorneys, and if you don't recognize it, if you send them into counseling, you may be able to have them rebuild and heal and move forward. Second reason, the support system, because people need a support system. And third reason, so they don't keep repeating their mistakes and marrying the same type of person again and again, maybe a different physical package, but the same emotional or underlying problems.
Absolutely, absolutely. And likewise, when someone comes to me for a divorce right away, reconciliation is something I always want to address with the individual first. And if there's any way to save the marriage, and would therapy work? but like you, I think engaging a therapist is very beneficial.
There's another issue, and that is that I'm seeing more and more. The word is parental alienation. And it's almost a quasi-criminal situation because you've got often one spouse is arguing that there's abuse, and the other spouse is saying, no, it's not abuse, but my husband or wife, and it's more often the woman than the man, is trying to alienate the children from me. Do you see that much?
See that a lot, and a lot of times there is alienation going on, and it's very difficult though when it's two parents with children that are at an age that really can't communicate effectively with a therapist or with the courts. But when the children are older, I find that it's harder really to defend against an alienation per se. If someone comes to me and says, no, I'm not alienating my kids against my wife or my husband, they're crazy. What I like to do is engage and say, well, you know, at some point, a therapist may be employed to speak, an independent therapist may be employed to speak with the children to find out really what the behavior is in the home. And their eyes usually get kind of big at that point because they realize if there is something going on like that. But but to go back to the domestic violence issue, it is a form of domestic violence. If you're using the children to control, if you're using them to control the other side or to alienate the children from the other spouse, it's abuse.
And I see it, I'm not saying it's in all cases, but I see it in a fair number of cases. And then the question is, again, does the family court system adequately deal with it? And my argument would be not.
Maybe not, but I find they're getting better. And I think the judges are getting better, and I think they're employing independent therapists and not afraid to do so, and get trained professionals to interview the children to find out what's going on. Because it's not only for the action that's pending before the court that may get resolved within 6 months, but it's co-parenting down the road when the parties when the relationship has ended, and you don't want that behavior to continue.
Yeah, and that's where you've got to somehow strike a balance so that they can move forward and co-parent.
Absolutely, and both parties really, I think, could benefit by therapy as well. I think is how to deal with that, but then how to prevent that as well.
George, are there any other areas where domestic violence and divorce or family court matters intersect that you'd like to bring to our attention?
Well, I think we've covered domestic violence, substance abuse, personal protection orders.
Well, criminal law per se.
Criminal law. Really, those are the main ones, Henry, that I found. I wish you and I would have had a conversation a little bit earlier because this idea of tort law really fascinates me, and that intersection with family law. But other than just criminal behavior or when someone comes to your office that's charged with a crime, and how that impacts post-judgment proceedings per se. I mean, we spend a lot of time focusing on a domestic violence case or substance abuse case where a divorce action hasn't been filed or is fresh in its filing. What about post-judgment issues where they're co-parenting children and a parent picks up a criminal charge, whether that be a misdemeanor or felony, whether that be substance abuse or physical abuse or whatever.
George, I want to thank you for being my guest on Practical Law. We're out of time now, and I want to thank you for watching Practical Law.